Hope you saved your really difficult pointed questions for the final bill. I know I've got a long list here as well for Representative Niave's bill. Representative Niave, you are recognized to lay out House Bill 625.
Thank you, Chairman Leach. Vice Chair Farrar, members, good afternoon. I want to thank you for the opportunity to lay out House Bill 625, which would extend the extremely short 14-day window to challenge an illegal tow in Justice of the Peace Court to a reasonable 60 days, and respectfully ask for your support for this legislation, which will help level the playing field against predatory towers. I filed this bill last session, which passed the Urban Affairs Committee unanimously, and it went to calendars. I do expect opposition today from the towing industry. The laws are, which I'll discuss shortly, are really stacked in their favor and against our constituents, and we'll talk about that shortly. But first, I'm going to discuss the problem that merits our attention. Second, how you challenge a wrongful tow, and third, why House Bill 625 will provide much needed, reasonable, and rational remedy for our constituents. And we know that not all towing companies abuse their power. This is for those specific instances that gives an individual a right to challenge an illegal tow. We know there are stories, I provided several of them to you right now, where predatory towers are, for example, staking out in parking lots, in apartment complexes, or at events, just waiting to wrongfully tow individuals. One of the articles that's in there, the Dallas Morning News, highlights a problem where we have 24-hour, quote, they call them spotters, who are tow truck drivers that, quote, quickly pounce whenever they see a car with, say, a missing parking permit or an expired inspection sticker, end quote. And that article talks about how some companies have been causing problems for years, and it's calling upon us as state legislators to do something to provide better protections for consumers. I'm also concerned in particular about this problem in low-income communities, many of whom we know already don't have access to justice or have limited access to justice or may not know their rights under the law. So, and really, when they pay the $300, $400, $500 to get their vehicle out of a towing storage, that's a really significant share of their income. Our communities, regardless of where they are, really rely on their cars to get to work, to pick up their kids from school and daycare, and it can wreak havoc on a family especially when they don't have those extra $500 in savings. The process to challenge an illegal tow in the courts is that you have to file a notice with the Justice of the Peace Court. You have a very, very short window, 14 days, only 14 days to file that letter. And then that gives you an opportunity to have a hearing or be heard before a Justice of the Peace Court to challenge the wrongful tow. It's been more than 2 decades, members, since we've looked at this law. 1995 is when the law was enacted, since that statute has been on the books. So it's really, really time for change. House Bill 625 provides this reasonable remedy. I believe it's fair to extend the window from 14 days to 60 days. And we have here one of our witnesses, who I want to welcome to come, who came all the way to Austin, Sergio Gonzalez. He's a college friend of mine. We both graduated from the University of Texas at Dallas, who brought this issue to my attention and the idea for this legislation. And I want to thank you for your consideration, and will reserve the remainder of my time to close, or I'm happy to answer questions.
Thank you. My first question, and then Chairman Meyer, just out of ignorance, and I hope you can answer this for me. What happens when a car's towed and there's a $500 fee for that car owner to get the car back, and that fee can't be paid?
That is a very, very good question. I have heard instances where individuals really give up their vehicle if they can't afford, and they lose it. They lose their vehicle.
That's a problem, especially for that single mom working 2 jobs who needs to get to that second job late at night and her car is towed. She can't pay a fee. That's a big problem. Chairman Meyer.
So are there any other avenues of recovery or relief for someone who's had their car towed? Wrongfully towed, sorry.
The other opportunity for an individual is that they can file a complaint with the Texas Department of Licensing and Regulation, and which is an administrative route that they can take. There have been I know that I believe we have TDLR here as a resource witness to be able to answer questions. It's a different route, but they do have complaints through that as well. This is for the judicial, and I'm not sure that they can maybe they can answer the damages that the statute under the Occupations Code provides for a wrongful tow.
So currently, basically what you're telling me is that we've got a 14-day statute of limitations to bring a claim for a wrongful tow.
That's correct, Representative.
Okay, thank you.
Thank you.
Can I?
Yeah, Representative Kraus.
Thank you, Chairman. What do other states have? Do we know, or have y'all looked into that? I mean, is 14 pretty average? Is it way short?
That's a good question, Representative Kraus. I'm not sure, but I can tell you, even to challenge a ticket, many municipals, ordinances have a 21-day or even 30-day. Most of the statutes of limitations on claims that one can bring are typically 2 years and breach of contract 4 years. So the 14-day window, I get maybe 25 years ago or 24 years ago when this law was enacted, maybe was reasonable at that time. But in light of the access to justice issues that individuals really, by the time they finally get their vehicle out and learn the laws and the rights that they had, that time period will have passed and they will have waived all their rights.
Members, further questions? Thank you, Representative Niave, and you reserve your right to close.
Yes,
members, we've got a few witnesses here. Vice Chair Farrar.
I just thought of something. Are we talking about tows off of private property or tows off of public property?
This doesn't specifically provide, it's the statute that governs wrongful tows in any circumstance. And so.
Thank you.
Thank you, Representative.
Thank you,
And you can come join us back up here if you want. Please do. Okay, with that, members, we've got 7 witnesses who've registered on the bill. 3 are registered to testify. There are 2 of them are against, 1 is for. So, Sergio Gonzalez, why don't you make your way up? Mr. Gonzalez, classmate of Representative Niave at University of Texas at Dallas. Welcome, and I assume you're here testifying on behalf of yourself.
Yes.
Is that right? Okay.
Yes, sir.
And that's for the bill?
Yes, this is for the bill. So thank you, Mr. Chairman and members. My name is Sergio Gonzalez. I'm a resident of Collin County in House District 89. I'm here representing myself to testify in favor of House Bill 625. So today I come before you as a concerned Texas resident, and I'd like to share my story. I believe this bill would help give Texas residents the proper time necessary to gather evidence and find legal representation against towing companies who wrongfully tow vehicles. On Saturday morning, October 29th, 2016, my vehicle was wrongfully towed from Prescott Place apartment complex in Mesquite, Texas. I was visiting the apartment complex to help register voters. I have lived in several apartment complexes, so I want to make sure that I parked in a spot that would not be ticketed or towed. After examining the parking lot, there were fewer than 5 vehicles in a row of 50 parking spots, so I chose to park at that row. After getting out, I did not see any signs, and the parking spots were not marked as residents only, so I began my work and started registering voters. An hour later, I went to my parking spot, and my vehicle was not where I left it. I spoke with the apartment manager and was told to call the number on the towing sign. In disbelief, I searched around and finally found the small sign at the entrance of the apartment complex, far away from where I parked. I called the towing company. Soon after, I went and paid $298.30 to pick up my vehicle from the storage facility. I felt like I had just paid a towing company almost $300 to hold my vehicle hostage for 2 hours. So I went back to the apartment complex to talk to residents. 3 different residents told me that that towing company had towed their vehicles several times, including the vehicles of family members who were visiting them. I found this type of towing at an apartment complex in the middle of a middle to low income neighborhood with difficult signage to be unethical and predatory. I wanted to fight back and take the towing company to court, but I could not. While I was researching how to fight back, I discovered that the people are only given 14 days to take towing companies to court. And it had already been more than 14 days when I found out. This is not enough time. The current system in place, which gives towing companies an advantage over Texas residents, I believe if I was given more time, I would have challenged them in court, and I believe I would have won. House Bill 625 will give Texas residents more time to gather evidence, find legal representation. I strongly urge you to pass this bill and give Texas residents the proper time to protect themselves in a court of law.
My name is Tasha Mora, and I represent myself. I am a tow company owner. I own 3 vehicle storage facilities, and I've been in business for 17 years. This is what a tow company can look like, okay? With that, I am also representing Southwest Tow Operators. It's a nonprofit towing association. We educate, train, and certify over 4,000 tow operators in the state of Texas. I am here to testify against House Bill 625, which proposes allowing the 60 days, excluding the weekends, legal holidays, and such for a tow hearing. I want to touch a little bit about the purpose of a tow hearing for those who may not be as familiar. So a tow hearing is absolutely to determine if probable cause existed for the removal of the vehicle and allow the vehicle owner or operator to recover the charges that were paid if they did claim the vehicle prior to the tow hearing. And if they did not claim the vehicle prior to the tow hearing, that way that vehicle would then be released and there would not be charges assessed. It's also there to help with addressing overcharging. Should there be a tow company in the state that's overcharging for tow fees and storage, then that's addressed at that hearing. Currently, the deadline is 14 days, excluding holidays and weekends. So during that time, the reason that it is there, it would be about 18 calendar days if you really were to pin it to paper. And it offers the opportunity for a timely resolution. That way, if someone did pay out the charges, they have that, they can recover those funds right away. If they did not pay out the charges, that way they're not leaving the vehicle in the facility as long and they can try to get that vehicle released. I want to also touch on the rates that tow companies and licensed vehicle storage facilities are charging for these tows and the storage. These are all regulated rates. They're not decided upon by the tow company or the vehicle storage facility. These are regulated. Now there is a process if they're overcharging. But as far as, I know the fees sound like they hurt. I absolutely understand that. But I want to be careful with tossing around $500 amounts because it does not cost that much the first date that the person is towed in the state of Texas. I also want to address that consumers are provided, the vehicle owner or operators are provided with their rights under the law, and I hear that's a huge concern. So should an individual claim their vehicle from a vehicle storage facility, at the point that they pay the charges, their rights and the process for a hearing is provided on those receipts. And furthermore, if the vehicle is left in a facility, then a certified letter is sent out to the registered owner or lien holder with those rights on there as well. That is when your 14-day count starts. However, in the event that you have someone that may not be practicing well and they do not provide those rights, there's no timeline. It's infinite, okay? So the vehicle owner or operator is protected in that way. I also want to give do you have a question? No. Okay. If this bill passes, the deadline, I want to talk about these deadlines. If a vehicle is towed today and this bill had passed, then the vehicle owner would have 60 days from now, not including weekends and holidays, which would be about 86 days out because there's an actual holiday in the middle of that. So it would be, the vehicle owner or operator would have up to May 28th to be able to file a hearing, On top of that, once a vehicle owner or operator files for a hearing, the JPs have up to 21 days to schedule that hearing. So we're looking at a vehicle potentially that is in a vehicle storage facility for 107 days. And I want us just to keep that in mind. The concern, I heard, how does this hurt? How does this hurt a vehicle owner or operator? Well, one, if you're keeping your vehicle in there for 107 days, that's a long time to go without your vehicle, clearly. Secondly, that's a long time to pay storages. But even at that, the vehicle owner or operator may be exposed to a greater risk, and that risk has to do with the disposal of the abandoned vehicles. So law enforcement has approximately about 30 days. Most vehicle storage facilities have about 45 days. And at that time point, then a vehicle can be disposed. So a vehicle could potentially be disposed of long before a vehicle owner or operator files for a hearing. Lastly, I wanted to just remind everyone that under Occupations Code 2308.404, vehicle owners and operators are further protected by that there's no limit to file for a hearing. Consumers have the option to sue in JP court. This filing also allows for the damages up to $1,000 plus 3 times as much the towing and storage fees if a towing knowingly and recklessly violates 2308. So if they knowingly, recklessly violate it, there's another remedy there. And that's more than what it costs to actually, for the tow fee and the storage fees. It goes above and beyond that. For these reasons, members, we would have to respectfully oppose the bill.